Good morning, everyone. Firstly, I'd like to thank Camelot for inviting Shergroup to allow Shergroup to do this presentation. Just to give you a bit of background, I'm Head of Property and Security Services, and you might be asking yourselves how Shergroup got involved with Camelot. The way we've got involved with Camelot is we deal with we're High Court enforcement officers, and we also have a security section at Shergroup Security. We do a lot of major evictions on the commercial properties and domestic properties, and they can allow our clients to have a further solution. So I'm working with Stephen at the moment, and I've got a client that's on the verge of actually taking this option for where we've got our security in and then we're moving Camelot in behind. So I just want to go through some of the changes affecting squatters' rights. Oh, this is good. Oh.
That's backwards. That's backwards.
Oh, it's backwards. That's why. This is. Oh, I've got it the wrong way around. That might be why, then, mightn't it? Okay, so just a little bit of history. Historically, squatting was not a criminal offence on domestic property. It only became crime if connected with other criminal acts, such as criminal damage, burglary, failing to leave the property, having been required to do so by the proprietor, and following the service of an interim possession order. There's a big grey area there, I must admit. You have to catch them in the act to actually get the police involved and for it to be criminal. I've just gone to a building in the last week, for example's sake. The police were there within 6 minutes, commercial building, and they climbed, literally had a concertina ladder, took them up on the 5th floor through a window. They've got it all on CCTV, but the police don't want to know. So this is where we're trying to support and work with Camelot and explain to you the changes. So the Section 144 of LASPO created the new offence of squatting in residential buildings, and that came into effect last September. Now what Shergroup are seeing, obviously we deal with the possession side, so if you do get squatters, this is where we can help you out. But what happens is, what I will say is where in domestic buildings the squats were very small, I would say you're almost threefold on size of squatters. So at the moment we're averaging up to about 30 people per squat in your commercial property. So what does that mean to yourselves as landlords? That's actually more cost than what it was, say, perhaps in the last 5 years. The government's options with Section 144 was to introduce the following consultation, and it was driven by growing concerns about squatting. The government reviewed a number of the options, and these included the following: maintaining the status quo and leaving the law as it was, criminalising the act of squatting, amending the law to offer a greater level of protection to the proprietors, and improving the enforcement of the law. So the new offence of squatting, government received 2,217 responses to its consultation on the issue, and 90% of these were in support of the campaign organised by Squatters Action for Secure Homes, Squash. Despite the opposition, the proposed change to criminalise vetting went ahead. So it does have a bigger impact on commercial property owners now. There's no doubt about that. We've seen a significant growth since last September in the amount of evictions that we carry out in relation to squatters. So the Section 144 of LASPO, this is intended to protect owners and lawful occupiers of residential properties from squatters and provides. What I will say is, just to touch base on this and to also help Camelot, I've been involved in a couple of cases recently. Stephen's also been involved in me with one that you could say is a residential building, and the police should help you with the eviction, and they should be able to just go in and get them out, no problems. But Stephen and I have learned on a couple of premises that's not quite the case, is it, Stephen? It's caused the client an absolute headache, and they had to go through a full eviction. So there are some grey areas still with domestic property. Although it was previously used for domestic property, there's this grey area of if it's commercial stroke domestic. So a person commits an offence if the person is residential building as a trespasser, having entered it as a trespasser. The person knows and ought to know that he or she is a trespasser in that property, and the person is living in the building or intends to live there for any period. Residential property for the purposes of the Act includes any structure or part of a structure, including a temporary or movable structure. But like I say, there's always grey areas in these squats, shall we say. Various scenarios. Section 144 includes persons occupying residential premises with the permission of a trespasser who will be considered trespassers themselves. And what I will say there, what we're also seeing a growth in at the moment on domestic is where a squatter actually goes in, and then what's happening is that squatter then sorts out leases, licences that aren't quite legit, and we go along and evict these people, and they think they're there genuinely. Some of them handed over like £5,000 and think they're in a genuine agreement to be living in that property. Owners of non-residential buildings will need to use the civil possession procedure to evict the squatters. No offence will be committed by a person who remains in the occupation after the end of the lease or licence, even if the person leaves the property and then re-enters it, and that's under section 1442. Landlords can use section 144 to evict tenants who stay on after the end of the lease, and their remedy will be to apply for a possession order. Squatting on open land, Paul touched on this, like travellers. That's quite a big growth starting to this time of year, and on your commercial they'll go into the car parks, and again they will rip out the lead and everything else. They just don't care really. The offence will be committed regardless of whether the squatter entered the property before or after the commencement of the section 1447. So, persons guilty of the offence will face up to 51 weeks imprisonment, a fine of up to £5,000 or both. Now they are looking, there is talks going on whether they are going to do the same with commercial, and we're just watching that. So it's just a few questions that we've been asked, and our comments here. Have the police got more powers to arrest squatters in residential buildings? The answer is yes. And have the police got the appetite to arrest squatters? In our experience, not necessarily. What's happening sometimes is the landlord will go along to the police, but in certain areas, and we respect the police very highly because we do work very closely with them, but what happens is in some areas they just haven't got the time or the people to be able to turn that round fast enough for the landlords. In our experience, not necessarily. Do the police have the resources to handle this new offence? We see cases taking, as I say, long to action as per the LASPO position, and some people are still choosing to take it through the High Court enforcement route to get the possession order, because it's the speedier way to get them evicted. Is the offence easy to prove? Again, media reports suggest that it's not an easy offence to approve and achieve conviction. I've actually seen a property where police have actually let some guys into a property. They had the land registry just changed hands, and the previous owner had the land registry, but of course the new buyer didn't. So when the police turned up to this dispute outside, that was only being commercial property, only being secured by mobile security, random visits, the police actually let the previous owner in and said to the new buyer, when you get your land registry details, bring them along and we'll sort it out for you. The police actually turned around and told them it's a civil matter and you need to go and get a possession order. That cost them thousands, unfortunately, on that occasion, because it wasn't straightforward people inside. So do homeowners know how to contact the police? In our experience, the answer is no. There is still an important role for professional advisors in this area. A lot of people still phone us if they've got squatters and everything else. So I think where Paul's focused mainly on commercial, I'm doing a little bit of a sale there for you, Paul, but at the end of the day I do think there is still a need on the domestic side for landlords. So Shergroup support. Shergroup has enforcement and security capabilities. Like I'm saying, I'm working with a local authority at the moment, and also working with Steve. I'm rubbish at names, I was just about to say Paul. And we're working there where we've done the eviction, and post-eviction you have got still a high risk where animosity with the protesters or whether the squatters or whatever still want to try and get back in that building. So what we're looking at working with Steve is we offer that security post-eviction for the period of time, and which also gives Camelot the time to be able to install it fit for their guardians. So we offer, it helps us allow a better one-stop shop and solution. As I said earlier, we're authorised High Court enforcement officers and therefore authorised to enforce High Court writs of possession, and we can assist in transferring those orders from the county court system into the High Court for anybody, and that we don't actually charge for that. We can also assist in preparing claims for possession so that transfer to High Court is easy to achieve. And we offer a complete solution to manage any eviction, any type, anywhere. Like I say, just to give you a background, it doesn't matter how small, Shergroup can actually help yourselves out on whether it just be a domestic 2-bed house, right up to St Paul's Cathedral eviction and protesters, Hobo Hilton a little while ago. So we've got the capabilities to do anything. Thank you very much.
Okay. Are there some questions for Ms. Wright?
Hopefully not.
In the new legislation, because I'm decant blocks, which are council blocks, and to demolish, is there a kind of, I get the impression with the action of the new law is that if it's, say, for example, someone's gone on holiday or they're away and they need help getting in, the police will do it. But if it is a council property with no protected intending occupier, that they will say you've got to do the full civil proceedings. Should it differentiate like that, or is that just likely what's going to happen in practice?
It's a very difficult one because we get a lot of people phone us where they've approached the police and the police have turned around and said no. We can't actually say what the police will or won't do, but if your local constabulary will not support you, then that is your only route to go for a possession order. The one that's, I keep referring to you, Steve, but you're my little buddy. The one I'm working with Steve, for example, say, very sort of similar thing really, wasn't it? You know, it was a building where individual people lived, individual flats, but it's viewed by the local police with this local authority that it's commercial. So we can't argue that fact. If the police won't support them, you've got to find another solution how to move them on or whatever. And unfortunately it is by going for an order for possession.
It's almost like the impression is, because it's the council, often if someone living in a block reports antisocial behaviour or what are criminal offences, they say, I'll phone the council. So
yeah.
There is that attitude, and there's also the thing, it is the council, it's not someone doesn't need to get back in their home, therefore they don't need to intervene, and that's what, I mean, the police do work very closely with us, but I do get the impression it's kind of almost seen it's a void council property, you're not reletting it, there's no one waiting to live in it, therefore go through the full civil route rather than just get the police in.
Yeah, and unfortunately we've got no control over
that. And the law doesn't differentiate, does it? It's just really more practice.
It doesn't, as I do use the word, there are, there are some grey areas, and it does seem to be, depending on where you are in the country, can depend on what support you get. That's what, it's the same as, it depends where you are in the country, whether you're waiting 10 to 12 weeks for your eviction to take place or whether you're waiting 10 days. So, they will tell you to go on a certain route. That's all I can say, and that's what we've experienced, like for the comments that we've put there, is that some people are being advised by the police that they need to take the civil route.
Thank you.
Anyone else I can give the microphone? Okay. I've got a question that's on my mind.
Really?
I'm allowed to. No, it's, we are about 2.5 years ahead of the United Kingdom. In the Netherlands, squatting became a criminal offence on the 1st of October 2010, both residential and commercial. And of course, the question was, would that affect your business in any way? Well, reality is our business has doubled over the last 3 years. And that came because of the... Did it work enough? We're going to time it like in Formula 1. 9 seconds to change tires. 7.8, good score. Thank you very much. In the Netherlands, squatting became a criminal offence, both residential and commercial, 2.5 years ago. Of course, the question was, would it affect our business in any way? Well, we doubled our business, and that came because of the owners, both councils, housing associations, and commercial business owners, were forced by politics to look into legal alternatives to create temporary residence. So the law was quite clear. Squatting is a criminal offence, and then 24 pages came with legislation where it gave the council a stick to hit those owners that are not willing to put their buildings back into business in any way, and b, a tool for the council to create temporary solutions in vacant residences, specifically the ones that were empty for years. Any of that, is that something where the United Kingdom is heading, or because we see that the steps are taken here are sort of similar?
I mean, Shergroup are watching it very closely, obviously, but I think there will still be that you'll have to go a possession order route in certain places.
Yeah.
Because there just won't be perhaps the police to act as swiftly as you want those squatters to move out. And I think that's what people are experiencing is the wait. I mean, I'm hearing one landlord, for example, say got quoted county court bailiffs the other week, 10 to 12 week wait for an eviction. Shergroup stepped in, took him through the route, and we saved him £6,500. So it depends how you look at it, because some people are going to look at it as a money-saving exercise, come to Shergroup or go to Camelot. Yeah. But you know, there's different options where you can save. So I think there will always be a route.
I have to clarify maybe a bit. In the 1980s in the Netherlands there were 50,000 squatters, and about 500 buildings were squatted in the Amsterdam area alone. With the new law in hand, the Council of Amsterdam started to evict buildings every other week. They did about 10 or 12. So, but the reason the council and the police evicted the buildings, because the owners that were first, they all wanted their buildings evicted with the new law in hand. The owners that were evicted first were the ones that came up with an alternative plan. They said, okay, once the building is evicted, we will put it into use as a temporary residence or that. Yeah. So today, the number of squatters has brought down to around 2,500 for the whole of the Netherlands. Less than 50 buildings are today squatted in the Amsterdam area, and those are the die-hard anarchists that are really not willing to move anywhere. But it's basically what was followed is, if you come up with a plan to both the police and the local council, okay, after the building is evicted, this is what we're going to do with it. It might be Camelot, but at least a temporary use to it, and that was then enforced by law as well. So those came first on eviction. That's sort of
I mean,
what we can see now happening.
Yeah. On some of the large-scale evictions that we do that might end up public order or whatever, where the police do assist us on the operation and they don't end up charging the client, what they do say is, very clearly in a planning meeting that's done between Shergroup, the client and the police, they will say you need to look at some form of security, because if you don't, you will pick up that police bill next time round. Okay. So they're quite happy to help on first time round, but not so much second time round.
They use it as a stick, not as a reinforcement.
Well,
okay.
There you go.
Okay. Well, yeah, it's slightly different. But then again, squatting becoming a criminal offence in the long run turns out to be a good solution. We can see it in the Netherlands. Squatting has almost disappeared. Yeah. Okay, any more questions for Ms. Wright? Not at all? Okay, then we'll have a short coffee break. Thank you very much.